You know, first of all, I wasn't aware of the Supreme Court decision, and based on that, and I'm glad to see that Mr. Avila is represented. He certainly has a claim here. Based on that decision, I think it's appropriate to set aside the order of September 21, 2018, and set this matter down for a hearing on the issue of paternity. The father's Mr. Olivia is represented, and that's one of my concerns. The other concern was the appointment of a guardian ad litem under the statute. But I think there should be a guardian ad litem appointed. And finally, after that's done, we need to have a hearing on the issue of paternity of now, I guess, the two children. The results came back that the plaintiff is the father, is the natural father, so apparently he's the father of both of the children, the natural father, but the legal paternity, of course, is the issue that needs to be addressed. And Mr. Oliva certainly has a claim there. And we need to resolve that issue before we proceed much further. It would seem to me that after we have resolved the issue of paternity, then we can address Mr. Avila's issues of custody and support. Is there anyone who disagrees with the characterization of that's where we are? Ms. Perosi, do you agree that's where we are?
Your Honor, I do disagree. Back in November of 2017, Henry Oliva filed a motion with an attorney just to have him joined for the limited purpose of determining paternity of the minor child, Alan Oliva. That was in November of 2017. As you know, Your Honor, Judge Elliott refused to give my client the opportunity to take a paternity test. He just was confirmed as the father on May 15th through DNA testing that he is the father of Alan Oliva.
He's the
now,
natural
Henry
father. We know
should
that.
not be a party.
I'm sorry?
He should not be a party to this action. In fact, Henry Oliva should not be a party to this action. In fact, he's the one who fraudulently submitted a fake DNA test claiming that he was the father of Alan. He signed the birth certificate, fraudulently claimed to be the father this whole time, and that's how he obtained custody. Now, he's the whole reason why my client has had to wait all these years to actually be determined to be the father, because they submitted a fake DNA test.
Okay, Ms. Perosi, that's an argument for the trial. It's not an argument on who ought to be allowed to be heard. It's not really an argument on the relationship between Mr. Oliva and the children. My understanding is that, and whether it's to one or both, I can remain unsure about that, but I think that under the circumstances that he would have the right to be heard. The whole problem we had was there apparently the conclusions that were reached by the judge were not done as the result of a hearing and without notice to the essential parties. We now have the essential parties. The Supreme Court has said we've got to determine paternity. The mere fact that he is the natural father of both of these children is not the end of the inquiry. The inquiry is who is the legal father, and we're going to have an evidentiary hearing on that issue. Mr. Oliva is going to be allowed to participate. I do want a guardian ad litem for the children. I think the statute requires the appointment of a guardian ad litem. So I want that done. I want that done at Mr. Oliva's expense. We can reassess that at the time of trial, but initially I want him to bear that cost of the guardian ad litem. I would suggest that the Children's Attorneys Project be contacted they may be able to either represent the children or to represent someone or know someone who could be retained to represent them. But I want that done quickly because I think both of these children, in view of what's at issue here, need to have a guardian ad litem represent them. If there's a conflict, we can address that. If two children take differing positions, I mean, we can worry about that. But at this point, I'm only going to require one guardian ad litem to represent the children. And we'll have an evidentiary hearing on the issue of paternity. We'll get all this hashed out, and everybody can make their arguments. But while it's clear that based on the paternity testing that Mr. Avila is the natural father of these children, he may not be the legal father. We know that. So we need to get down to that issue to get that resolved. Once that gets resolved, then we can discuss support and custody.
So, Your
Your
Honor,
Honor,
I'm
as
sorry.
to Jaslyn,
I'm sorry.
there is already.
What?
As to Jaslyn, there are already custodial orders, and mom has had primary physical custody since March of 2017, and legal custody, they have joint legal custody. But as to Alan, which my client was just
The difficulty is I don't know that Mr. Olivia was a party at the time that those orders were entered. And the reason I'm saying that is because he was my opinion is notice should have been given to him formally, and he should have been given the opportunity to be heard. And the problem is that just because you had an order entered, just because you had an order entered in an action between Mr. Avila and Ms. Martinez does not impact Mr. Olivia's rights, and he's here now. I mean, this decision, in my opinion, works both ways. We're going to set it down for the evidentiary hearing on paternity as to both children with the appointment of guardian ad litem. If you think you're entitled to summary judgment,
I just want to be clear.
Ms.
Mr.
Mercer?
Oliva was never a party to Jaslyn. I don't believe he should have ever been a party. He's not claiming to be a third party to Jaslyn's action. He only joined in as a third party to paternity of Alan Oliva, which now my client's determined to be the father of Alan. So he was never requesting
he was in a
party.
relationship with the mother,
Jaslyn,
and he had
and
the
he
care
was
of the child. They weren't they living together at the time?
Yes, Your Honor.
They've been living together on and
That's
off
not
for all these years.
Yeah,
And,
no. The answer,
Your Honor,
Ms.
this
Peruzzi,
is
I'm
the
inclined.
thing.
No, he was entitled to notice. He was someone who
Yes.
obviously should have been given notice and the opportunity to appear, and at least been given that opportunity. Now, you did something if you served him with the notice and what have you, but he's someone that he was in a relationship with the mother at the time. They were residing together. Evidently, this is a long-term relationship. So, I mean, I'm not.
But he's
at
not
this
the father.
Point, I'm not at this point.
He's never
going
been
to
the father
accept
of
that,
either
no.
child.
What?
Well, the paternity test is clear. He's not the father of either child.
Ms.
Just because he
Peruzzi,
signed a birth
Ms.
certificate,
Peruzzi, we're not going to argue it
he
anymore.
was never married to Rosie.
Doesn't matter. I mean, here's the point.
Yeah, it does matter in this situation. So does that mean? Excuse me. So does that mean that
Mr.
I
Avila?
can take care?
Mr. Avila, no, you got an attorney. Ms. Mercer.
Thank you, Judge. You're absolutely right, and that is exactly what I was going to bring up, that there's never been notice and an opportunity to hear. Mr. Oliva was never considered. He was the legal father when these children were born. He was the only father they ever knew. He was on the birth certificate, Your Honor. So you're exactly right. He had a right to be heard, and there's never been any pleadings alleged against him.
If he was on the birth
procedurally, this
certificate,
case
Ms.
is-
Peruzzi, he absolutely was entitled to notice.
And there was
Just because
never
somebody signs a birth certificate doesn't mean they're the father. He did it by fraud, Your Honor. He could
Well,
claim
you
he's
can
the
argue
father
that.
of the
That's
birth
twice
certificate.
already.
No.
And my client had to prove to the court that he was really, through paternity, DNA testing, that he's the father, and his rights need to be considered. He's the one who's being harmed here. Why is Henry Oliva, a third party, who's not even in a current relationship with Rosie, being considered. My client has been missing
Okay,
time with
then you
his son
misunderstand the
because of
concept of
Henry
paternity.
Oliva.
Ms. Peruzzi, you misunderstand the concept of paternity if you're taking that position.
I don't.
Here's what I'm going to do is I was right. I'm going to set aside the order of September 21st, 2018. I'm going to set an issue first on the issue of paternity. I'm glad that Mr. Olivia has an attorney that resolves one of the issues I was concerned about. Notice to him. And the minutes will reflect that he is here represented by Ms. Mercer. The hearing will be as to both children. As to the paternity, as to both children, the court finds that Mr. Olivia has not been given notice and opportunity to be heard on the paternity as to Jaslyn, but it will be on as to both Jaslyn and Alan upon determination of the issue of paternity.
He has, Your Honor. It's in the pleadings. He was given notice. He lived with Rosie. He knew what was going on. I was not the attorney as to Jaslyn.
Ms.
He was
Peruzzi,
given
if you
notice.
continue to argue with me, we're going to have some difficulties. I made this decision 3 times. You can argue it at the time of the hearing. You can argue whatever you want at the time of the hearing. I'm making a decision today. Do you understand?
But it's incorrect. The pleadings say differently. I don't want wrong findings.
Ms.
Your Honor.
Peruzzi,
We have to
one
go
more
to the
time.
Supreme Court on the
One
same
more
thing.
time. That's the last time. You got
I
it?
want a visitation schedule for my client who has been missing time with his son.
You're pushing it, Ms. Peruzzi, and it's not appreciated at all.
I'm sorry you feel that way, but I've been fighting this case for over 3.5 years and went up to the Supreme Court. It was reversed and remanded back down just to get justice for my client, just so he can prove he's the father of his child. I'm a little bit frustrated at the system.
Ms. Peruzzi, if you want my
Judge
honest
Elliott
evaluation,
reviewed.
just so that you know, the case was mishandled in the first instance. Had the plaintiff in this action, your client, given the proper notice to all the parties that she should have given notice to, this would have been resolved years ago. You're right, but it was your
No, he did give
incompetence.
proper
It was your
notice.
incompetence that has gotten us into this box. Do you understand that?
No, it was not my incompetence, Your Honor. Oliva was given notice November 2017. They filed an action to have him join
Ms. Peruzzi, I'm done arguing with
the
you.
Register of Actions. It's there. It's
I'm
clear.
done arguing with you, Ms.
If you
Peruzzi.
read the Register of Actions included. Okay. I don't want you to say I'm incompetent on the record, because that's untrue and unfounded.
We just have to disagree, I suppose.
Okay,
The
let's do
first
that.
trial is give me a date on the issue of paternity.
How far out would you like it, Judge?
A couple of months. It shouldn't take very long.
I can. August 31st at 9 a.m.
Okay, August 31st at 9 a.m. Again,
Let me look at my calendar, please. I'm sorry, I need to look at my calendar.
Your Honor, while we're waiting, who did you say has to pay for the guardian ad litem? Was that Ignacio or Henry?
that is
Henry.
Mr. Avila Ignacio.
No,
Mr.
Your Honor, you said Mr. Oliva has to pay.
Well, then I was
Why do I
misspoke.
have to pay?
I intend that Mr. Ignacio, the person who's the plaintiff in the he needs to pay for it. He's the one that has the obligation
Your Honor,
under
rewind your
he's the
tape.
one that has the
You said
obligation
Mr.
under the
Oliva.
rules to comply with the statute. So I want him to bear the initial cost of the guardian ad litem.
And Your Honor, I believe
But
you agree
before,
with
Your
me
Honor,
that
you said
there's
Mr.
never been
Oliva.
any, excuse me. I believe that there's never been any pleadings filed alleged against my client whatsoever. So I agree with you that there's never been any due process here. And that is exactly what I was going to try and argue today.
Well, a paternity action is a noticed petition. If he has notice of the petition and the hearing date, if it was served on him, for instance, and he failed to appear, I mean, it's notice to all the world of sorts. I mean, it's a paternity action is a notice hearing. It's a petition hearing, not a complaint directed at certain people. The court would have required that notice be given to those who are in a position to maybe make a claim for paternity. Certainly, Mr. Olivia was. It should have been given. It should have been served with the notice and the petition. If he were served
Mr. Oliva
and
was
failed to
present
appear,
at the hearing.
Ms. Peruzzi, I'm so tired of being interrupted by you.
I'm sorry,
whoever's
but he was
interrupting.
present at the last hearing. He's been present.
If he has received, well, if he's present, then he's entitled to it. But there has to be some notice of hearing and then a clear opportunity for him to be heard on his issue of paternity as to both children. I'm simply going to have that issue determined as to both children. That's all there is to it.
Okay. But even though he received the petition it was alleged against Rosie, there's never been anything alleged against him. There's never been a claim for relief
Ms. Mercer, my
against
concern
him.
is that a paternity petition alleges that someone is the father.
But his name's not on there.
Well, the
I'm
issue.
agreeing with President.
Let me explain something to you. A paternity petition is a petition that says, "I am the father of the child." The issue to me is one of notice. Prior to any determination being made, was he given notice, or to the conclusion of the petition, was he given notice that the petition of Mr. Avila was that Olivia was the father of Olivia, not just the paternal, not just the blood father, but it was he in fact the legal father of Olivia. If he was served with notice of the declaration, if he was served personally with the notice of the declaration that Mr. Oliva asserted that he was the father and he did nothing, then he would be bound by the consequences of the judge's decision. But the issue to me is if you have a person who is living with the mother, who's on the birth certificate, you are required not just simply to file a petition and do it generally and to serve it on the mother, you're required to specifically give notice to someone who could very well be the father and in fact is claimed under, I understand, under the birth certificate or under the circumstances under which they were living, that he in fact was the father. So the issue to me is really one of notice, more than it is whether or not some claim has been stated, because the claim is that Mr. Avila stated he is the father. That prima facie would exclude any other person in the world, any other man in the world, I suppose. And so that's the issue. It to me was noticed. He should have been noticed. Did he have to be named in the petition? Again, these are petition hearings. These are not complaints. They're not actions against him to exclude him, but it's a matter of giving notice to someone who stands in a very clear position of asserting an adverse claim. Does that make sense?
Your Honor, Mr. Oliva was given notice. He was given notice. He actually appeared at the hearing and was represented by counsel.
Well, I would assume that if he did that, he may have waived notice.
He appeared at the last hearing.
No, we're not talking about the last hearing. We're talking about the hearings where.
He appeared at the hearing in front of you.
Not that hearing, Ms. Peruzzi. I know you're trying to do this, but the answer is before any determination of paternity was made. Before any determination of paternity was made, was he given notice? And
yes, he was. He was given notice and he appeared at the hearing.
At which hearing?
With his counsel, and Rosie appeared with her counsel. And I was present, and I requested paternity test, and I was denied. And I requested an evidentiary hearing, and I was denied by Judge Elliott.
I have not set aside that order. I'm simply, and I don't have the complete file in front of me, and I'm not going to research it now, but I'm leaving it on for determination of that issue because I'm not sure that I think he was given notice, especially if he was on the birth certificate. If he was on the birth certificate, he should have been given notice from day one. He should have been treated.
And he was.
You served him with a copy of the petition, personally?
Yes, Your Honor, he was present. He was served a copy and he was present
Yeah.
at the hearing, Your Honor, with counsel.
Is that right, Ms. Mercer?
This is the whole mistake that happened with Judge Elliott. She refused to give
Okay,
my
Ms.
client
Mercer,
a
was that
paternity
correct?
test,
Was
stating
he-
that the
was
child
he
was
served
over
with-
3 years old.
Is there an affidavit of service in the file showing that he was served with the petition initially, or some other?
There should be, yes, Your Honor, and you can watch the video. He was present with counsel at the hearing when I requested a DNA test
Of who?
for Alan.
That's not the hearing we're talking about.
Alan. Okay, well, I was not counsel for the hearing with custody of Jocelyn. Either way, he was involved. And
Clearly,
there was-
he is entitled to have a hearing on the issue of paternity of Alan. We know that. Alan's not the issue. I thought we were discussing Jocelyn. I don't know.
Okay, well, there's two
But
kids, and
but the results
Jocelyn,
the same.
like I said, Mr. Oliva was involved, and he knew his name's in the pleadings, and my client and Rosie came up to a stipulation. I can't tell you about that case because I was not counsel for the plaintiff at that time.
That's the one I thought we were talking about.
But I know Mr. Oliva had
Ms.
noticed.
Peruzzi, I've made my
been
point clear. I
involved
don't
in
intend to
these
argue with you. We're going to go back to, and I read the Supreme Court decision. I think we need to go back and do what the court said, and that is that on both of these children, go back to square one and determine who the legal father is. That's the first issue. Who is the legal father? We now have Mr. Oliva before the court, we have Mr. Avila before the court, and we have the mother before the court. There's going to be a hearing on that issue. Raise any issues that you want. The children will have a guardian ad litem. Once the court determines who, in fact, is the legal father, then we can discuss issues of visitation and neglect. Ms. Mercer, would you prepare an order, please?
I'd be happy to, Your Honor. Thank
And
you.
we got the hearing date
I'm
set
sorry,
for
do we have a date for
August
for the
31st at
trial?
9 o'clock. That's
This
the
is
trial
full
date.
day?
The full day?
Sure, why not?
No, it can't be
Thank
a
you.
full day, Judge.
Your
I'm
Honor,
sorry.
I would like, is there any way we can get some temporary visitation schedule for my client and his son, Alan?
Not
In the
until
meantime?
August.
Judge, that can't be, I will have to change the day if they want a full day. Because he stacks his on that day, so Ms. Peruzzi said she was gonna look at her calendar.
These calendars are all going
I'm
to be passed
available.
out. Give me the date. That'll be the August
31st at 9 a.m.
August 31st at 9 o'clock. That's the hearing date.
So, am I allowed to see my son?
Sir, we're going
We'll
to make a
discuss
determination
that.
as to whether or not that's your son.
It is his
The
son. He's
paternity-
the biological
paternity
father
test.
of Alan.
And she has a
Hey,
sister.
look, I'm done arguing with you, with all of you. The nature of paternity is such that it isn't determined by blood test alone. And Mr. Ignace or Mr. Oliva, your grinning is not going to win you any points. Do you understand that? I'm still a district court judge, and we can deal with that kind of behavior. The bottom line is I know you and your attorney don't agree with some of the decisions. I frankly looked at this case this weekend, paid a lot of attention to it. The court has, first of all, directed that we set up the issue of paternity as to whether you are the legal father, not the natural father. We concede that you're the natural father of the child, but whether or not you're the legal father is something that has yet to be determined. Between now and then,
My client has
It'll
had a
stand like it
relationship
is.
with both of the kids his whole time. So,
we're done.
Thank you, Your Honor.
Who's gonna prepare, Judge?
thank you.
Mhm.
Who's gonna prepare the order?
Ms. Mercer.
Ms. Mercer.
And I will review and sign off.
Certainly.
Is that
Thank
correct,
you.
Judge?
Yes.
Okay, thank you.
Have a good day.
All right, we're done.
We're done. We're off the record.